Hello and welcome. This is your weekly fix. I'm Smita Nair. Earlier this month, the Supreme Court asked the government to respond to a plea filed by the National Commission for Women to raise the minimum age of marriage for Muslim women to be on par with persons belonging to other faiths. The plea states that, except in the case of Muslim personal law, the minimum age of marriage under various personal laws is consistent with the prevailing penal legislations. The Supreme Court is also hearing an appeal by the National Commission for Protection of Child Rights against a judgment of the Punjab and Haryana High Court, which upheld a 15-year-old Muslim girl's marriage. The NCPCR, in its appeal, told the Supreme Court that the High Court's order was at odds with POCSO, the Protection of Children from Sexual Offences Act, which deems sexual intercourse with a minor, someone below 18 years of age, as sexual assault. The age of consent, you would recall, was increased from 16 to 18 years in 2012-13 to bring it in conformity with the then newly passed Protection of Children from Sexual Offences Act. Now, earlier this month, the Chief Justice of India, echoing various high courts in the country, flagged the issue of criminalisation of romantic relationships between adolescents under POCSO. He appealed to Parliament to review the age of consent, something the government has now said in Parliament it does not plan to do. Meanwhile, child marriages in India have seen a steady decline, but is even today, as per the National Family Health Survey data, at a worryingly high 23.3%. All of the issues I've mentioned here are interconnected. Let's try and get some clarity on some of those questions from Madhu Mehra, founder and former executive director of Partners for Law in Development, a legal resource group on women's rights. She currently heads its research and training. Thanks so much, Ms. Mehra, for agreeing to this conversation here at Scroll.
Thank you, Smita, for having me on your program.
Right. To begin with, Ms. Mehra, we know that the bill to amend the Prohibition of Child Marriage Act 2006 to increase the minimum age of marriage of females to 21 years, and currently with the Parliamentary Standing Committee, states that the amended act will override any other law, custom, or practice. My question is, since there appears to be some confusion even among our readers and viewers, does the Prohibition of Child Marriage Act 2006, as it is presently, override or prevail over personal laws that govern marriage? The reason I ask you this is specifically on the ground, two child marriage prohibition officers have the power to stop the marriage of a minor belonging to a particular faith or a certain community or tribe, the personal laws of which or the customs of which allow for the marriage of a minor.
Yes, so let me answer this question. Actually, it has a couple of different issues which have been raised in this question. One is that the PCMA, as it's called, the Prohibition of Child Marriage Act, 2006. It sets a minimum age of marriage, but it declares that marriages between minors or those who are underage are voidable. They are not void. So only in exceptional circumstances are they considered void. We can discuss those circumstances, but by and large, they are considered in general voidable, with the underage party exercising the right to nullify the marriage. So that's how it stands. It gives no, there is no overriding nature of this law, because the personal laws also set a minimum age of marriage, but they do not declare these marriages or do not hold underage marriages purely because they are underage to be void. So, for example, the Hindu Marriage Act does not treat age of marriage to be a reason for holding a marriage to be void. There are other grounds on which a marriage, once contracted under Hindu Marriage Act, will be void ab initio, but not the age of marriage. So, age of marriage is being set. There's a mandatory minimum, but of course, that minimum is, the child marriage continues to be prevalent, or rather, what we would call early marriage, because they're older adolescents, which is the bigger trend in India. And now the question about whether a marriage which is voidable can be stopped, or can a child marriage protection officer go ahead and stop a marriage from taking place, although it is voidable under their various personal laws and under the PCMA. Yes, they can. And there is that is the duty of the child marriage prohibition officer. They are meant to be identifying marriages when they take place. They are meant, and including third parties such as NGOs, social workers, frontline workers, and they can take steps to stop such a marriage and have an injunction passed against it. Now, once an injunction is passed against such a marriage from taking place, and if a marriage, despite the injunction, goes ahead and does take place, it is considered void under the law. So, one can stop a marriage from taking place. That is purely within the powers, not just of the state functionaries, such as the CMPO, but also of other entities like NGOs and social workers and frontline workers. So that's entirely possible. And in fact, the girls also, or the minor party to a marriage, may also seek to stop a marriage from taking place. And we know several NGOs working at the community level, working with adolescent groups, do take those steps when a girl reaches out, and or they hear of a girl who's getting married forcibly. So they do reach out and they do take those steps. And that is exactly what minimum age of marriage means, that you can stop a marriage from taking place and you can exit a marriage. So if the marriage is voidable, it really means the party to the marriage can exercise the option and
Okay.
nullify the marriage, which is not the same as divorce. So that is the advantage of having a law like the PCMA.
Okay. What about the Protection of Children from Sexual Offences Act? Does it override personal law? Again with
Yes.
reference to, yeah, right.
So that is a very different law. It's a very serious criminal offense. Now, the punishments in PCMA are 2 years and thereabouts, whereas the punishments in POCSO are of a different nature. We're talking about sexual offenses here. And that very expressly has a provision. There is a provision in POCSO which says it overrides all other laws if there's a contravention. To the extent of contravention, it will override. So that's different. That's a case of sexual abuse. When sexual abuse occurs, then the law has that overriding power. But it's very different from, say, underage marriages, which are a different kind. It's not entirely. It's also, look at the material available on it. It's described as a social problem. It's not an act which is intentionally carried out, to violate the law. It's not. There are customs. There are customary practices, which vary across the country. I mean, this is a very diverse country. In fact, the Hindu Marriage Act makes allowance for customs and customary practices too. So there's also, of course, the situation that people, and we can come to that perhaps, if that's what you're looking for to discuss, what is the social groups within which underage marriages are happening. And that
Hmm.
makes sense, when you correlate poverty with underage marriage, then you begin to see that it's not an act of intentional violation where
Hmm.
you're out to in a sense intentionally do commit a wrong. It is part of the circumstances in which you're born. There's livelihoods not available to you. There's vocational education not available to you, or it may be available but it's not accessible in the area you're staying.
Hmm.
And in those circumstances is where we are seeing underage marriages take place in large numbers. So if you correlate the social context or the resource poor context within which child marriage occurs, it's a very different kind of, one would not describe it as a heinous offense. One would continue to describe it as a social wrong, for which multifaceted remedies are required.
Right. So therefore, it would be, if would I be right in saying that the prevalence of child marriage isn't necessarily higher in communities, the personal laws and customs of which allow for a girl to be married on attaining puberty, but that there are other secular factors, like you said, for example, poverty, that drive the practice of child marriage in India. Would that be correct?
Absolutely correct, because the age of marriage. It's not the law that drives people to marry on at 15, at 25, at 35. It is really their circumstances. And we are seeing that, the if you look at the national data, not just the NFHS 5, which is most recent, but even if you look before that, at NFHS 4, which is 2015 to 16, it squarely correlates with poverty. Poverty correlates with marginalized communities. So it's SC/ST communities where largely you would find underage marriages take place. In rural areas where there is very little by way of infrastructure, in terms of quality education. So that's where the dropouts are the largest at the secondary level. And it is, if you look at NFHS 4, it also gives various reasons why girls have dropped out of marriage. So the first being lack of interest in studies, which correlates with poor quality of education.
Hmm.
The second being the high cost of education, which means that a lot of people prefer private education to government schools because they don't see the government schools transforming their lives. The quality of education is quite poor. And the third biggest factor is actually the unpaid burden of housework that falls on young girls. So that is one of the biggest factors why girls have to drop out of school. So those are the reasons why girls, and so it's not that girls are getting married and therefore dropping out of school. It is that they actually are in infrastructurally deprived circumstances, in resource poor contexts, and they don't have education. They have to do work, whether it's housework or it's a paid work outside, laboring work, and for that they need to be married. So you find, in fact, studies from West Bengal which have looked at this question. And it's very interesting that as long as the girl is not married, she can work at home, but natal home will not send her outside for paid work. And when she's of the age when her labor can be used productively outside of the home, then she is married. So it is, and in that resource poor context, the boys are equally not very well qualified, barely passing school or senior secondary, and take up jobs early. In fact, what is interesting is that if and the uh, government too recognizes this, because the labor laws allow for 14 as the age, 14 and 15 as the age, whether in Factories Act, Apprentice Act, Plantation Workers Act, to begin to work in non-hazardous industries. So it is not the middle class children who are going to work in these places. It is not the middle class anymore that gets married early. And already, as we see, the profile is changing in India. It is largely early marriage, not child marriage as we know it. And we are also seeing that it is very, very deeply linked to poverty and insecurity. And yes, customs to a limited extent, but not entirely customs. That narrative that it is entirely driven by customs is no longer holds, because those who move on to, if you see, I have the figures here from, actually, a analysis done by UNFPA on the NFHS 5 data. And
Right.
it says that 40% of the underage marriages are happening in the lowest wealth quintile, and only 8% in the higher wealth quintile. So you see, that's the disparity. That's where the problem is: not having opportunities, not having the skills, and therefore, relying upon one's labor, both for reproductive as well as for productive employment at a very young age.
Right. This leads me to ask you two questions. I get the point that you're making, but you're not suggesting that the law isn't needed. I mean, the PCMA does have has played a role in dealing with the issue of child marriage, albeit to a limited extent. Is that correct? Am I right in saying that there is a need to have a mandatory minimum marriage law? One, and B, what is your analysis of how this law has uh, sort of worked since the year 2006 leading up to 2022? I understand a number of studies were carried out. What does it tell us about how the child marriage law has sort of played on the ground?
So I would say that a mandatory minimum age is necessary, and a minimum age should be really one which correlates with the age of majority, not less, not more. Because an age of majority does not mean the age of maturity. It does not mean that one person or person will have capabilities that we assume that well qualified mature adult will have. The point about the age of majority is it is arbitrary to some extent, and universally across the world, 18 is considered the age of majority. So and in our laws too. So I would say that is necessary, and we already have the law. There are some very good features in the PCMA of 2006, but of course more is possible, and I'll come to that. uh, uh, it allows for this qualification of valid though voidable. So the marriage, you see, once a marriage happens, there's a huge stigma in our country, and not just our country, the whole of South Asia, if I might say so, on female sexuality. So when girls themselves are when they find somebody that they a boyfriend, they or a long term relationship, the desire is to get married, because outside of marriage you're not allowed to hold a relationship without being stigmatized. So most of these relationships are conducted under wraps of secrecy. So that's one scenario. The other scenario is arranged marriage within India, which is the most prevalent form of marriage to date in India. And once a marriage occurs, it would be very difficult for the state or any other third entity to turn around and say this marriage does not hold in the eyes of law, um, because it is really then up to the two parties who are vulnerable in some. If they're vulnerable by definition of age, then they can declare it void. If there is domestic violence, then there are laws to which mandate intervention and support to the wife. So there are many laws in place which will breach and should breach the marital home when there is trouble. But merely because the age is 2 years up or down is not sufficient reason to declare a marriage void. And that's the whole thing, the concept of valid though voidable. So it's contingently valid. It's contingent on the will of the minor party, and the which means that the minor party can go to court and must have a say in matters affecting her life. It cannot be a blunt law that will suddenly declare the marriage to be invalid. So I think that's a very important facet of this law. Another is that they have the right to maintenance even if they choose to not stay in the matrimonial home, and they have the right to be protected against forced sexual relations. We have the law, and they have the right to residence. So there are a host of protections. The only I would imagine the only way to build on this is to build in more protections rather than take away the kind of the nuancing that exists in the law. Now, the good question, I think the very important question you asked is, how is the law being used? It's been there since 2006. Now, we looked at 10 years of how the law was being used. And if you look at the NCRB data, it will show a mere 500 or less cases registered in a year under PCMA. But it will show something like 30,000 or around that huge figure of cases which involve kidnapping for the purpose of marriage. And that's one data you have. When you look at the case law of child marriage prosecutions, and the prosecutions are not only on under PCMA, they could be under the Indian Penal Code, they could be under POCSO, they could be habeas corpus cases, they could be bail cases by which will give you a insight into what is the case about. Now, what we found is 65% of all cases being prosecuted in relation to child marriage involve those filed by parents of the girls who had entered into self-arranged marriages with men known to them or boys known to them. So essentially, it is parents of girls who are using the law or weaponizing the law against against the choice of these girls to enter into marriage. Now, 35%, you would ask, what are the remaining 35% of the cases? Now, the remaining 35% of the cases, interestingly, very few are injunctions by the child marriage prohibition officer. We found that functionary to be almost inactive, although that functionary has the responsibility to stop marriages. You find many marriages which may be parentally arranged marriages, but they are coming to court to nullify it because the marriage has broken down. So the parties don't see any purpose in continuing with the marriage, not because of age of marriage, but because the marriage has broken down. They're unhappy with each other, there's incompatibility, there may be domestic violence, there may be dowry issues, the girl might have left her marital home and not returned, so on and so forth. So the you see, when the parents of the girls prosecute the self-arranged marriages, the provisions of law that they can invoke are much more stringent, such as POCSO, such as rape, such as kidnapping, and they come with 10 years sentences. Whereas when you sort of nullify a marriage that is not working out, there would be actually no penalties involved. So, that's the disparity. It's very discriminatory in its use. But fortunately, what we find is that the courts have chosen this approach where they, by and large, go case by case. There's a very sort of defining case, Lajja Devi, which actually was clubbed four cases together, and it was taken up by the Delhi High Court, and all four cases were different from each other, where the court in its wisdom felt that you have to go to address these cases based on the facts, different facts and circumstances. A singular approach which is uniform will not work. So, one of the tests that the courts definitely use is whether the marriage is valid under the personal law. If it's an interfaith marriage, it may not be valid under personal law. There have been cases where a Muslim girl runs away with a Hindu boy, gets married in a temple. That's not valid because a Muslim girl cannot get married in a temple.
And it's
So
not under the Special Marriage Act because you're not a major.
can't be under the special. But
Yeah.
where the marriage is valid under the personal law, and where the both the parties to the marriage, especially the minor party,
Hmm.
insists she wants to remain in the marriage, insists that she will be at risk if she's forced to uh, part from her husband and be sent to her natal home, the courts definitely take an empathetic view, which is very important because this is about protecting the rights of the child. It is not about protectionist approaches, which is a different term and different connotations. It is protecting their rights. And the Child Rights Convention is very categorical that consensual relationships cannot be criminalized and should not be criminalized. To that extent, I would say POCSO violates the CRC. It is not consistent with the CRC because it is in increasing the age of consent to 18 years, which is the same as the minimum age of marriage. It is not allowing adolescents the right to consent to a relationship that is non-exploitative uh, in nature. So
Uh,
if so yeah I will also add that Karnataka, as you probably know, uh,
yes. Brought an
amended
amendment.
amended its law in 2016, which came into force in 2017. It would be very important to look at how void ab initio has worked in Karnataka. Because one of the important things about Karnataka is the Shivraj Patil Committee report of 2011, which also made an important correlation of poverty and in the northern districts of Karnataka with the high prevalence of child marriage. And in fact, set down many recommendations to address those who are most marginalized, especially the migrant workers' children. So I think there is, wherever we have had the in-depth studies such as the Shivraj Patil Committee report, you will find there's enough information on the drivers of underage marriage, as well as of different kinds of interventions necessary to prevent to the extent possible.
So, what are those interventions broadly, Ms. Mehra, that in your opinion have worked in addressing this practice of child marriage? And what are some of the interventions perhaps that you would like to see but haven't come through?
So I think, I mean, going back to even what many of the recommendations of the Shivraj Patil Committee report, but in the last few years there have been a lot of discussion and churning on these issues as well. What is clear is that we need right to education to come up to 18 years, and we need quality education available in schools, in government schools. It cannot be the way that the government schools are not perceived favorably even by rural population. Where they can afford, they will send their child to private schools. So I think that definitely needs attention, and quality education without sort of segregating on the basis or discriminating on the basis of caste, where we hear stories like that also being highlighted in the newspapers. And I think those issues need to be tackled. And there should be, one of the issues that come, the reasons why girls drop out is also distance of secondary schools to the villages, as well as the non-availability of hygienic sanitary toilets. Because if they are not, toilets clean, hygienic toilets are not available, girls, once they start menstruating, begin to drop out. It's not, it's naturally they have no other choice. So I think that's one. But also quality vocational training needs to be available, and affirmative action to ensure livelihood and employment for girls is very important, because the idea is not really that they should marry at 18 or 18 and a half. The idea, really, the goal should be that girls need to be empowered enough to decide whether they want to marry at all and when they want to marry. It should be their choice. It's not simply a question. Empowerment doesn't stop at marrying at 18. You see girls who are women today who are professional, younger women, they're not immediately rushing to marriage because they can actually determine, they can sustain themselves, and they can decide when to marry. So I think there is a need to have a more a focus on women's empowerment and girls empowerment, where the choice is theirs. The idea should be, how do we bring them up to speed, both materially and ideologically, with the right messaging, where they choose when they want to marry, if they want to marry, who they want to marry, and so on. It's I think the child marriage issue is important to set a minimum age, but is not the benchmark for empowerment or progress. We have to look beyond that when we are sort of visualizing what might be the pathway for girls' education and choices, and autonomy. And I think it has to be much, much bigger than that. So I would say education, livelihood, definitely, also safe spaces. You see, after 2013, when the law reform on rape came in, the discourse amongst in the within the women's movement has changed, and it's no longer about, we don't want to be, we need a good law to protect us. Women are asking for safe cities, safe villages, the right to move around, mobility, safe transport. So women want to be equal to men, and young, and it has to start young. So if I think these are the building blocks for women to actually be able to be in charge of their own of their own futures, and to be able to have that confidence that they can do it. So age of marriage is not the highest threshold. uh, there's a lot more needs to be done. There's the whole issue of nutrition and stunting that has also come out in NFHS 5, which means that definitely nutrition has to be made available, and not just through schools but through various other programs. We saw what happened in COVID. So I think those are the gaps that need to be addressed, and structurally, once the conditions are improved, this, along with a host of other issues, would be addressed.
Right. You've sort of answered partially my next question. The push by this government to increase the age of marriage for girls to 21, I infer that you would perhaps say what you've already said, reiterate the points that you just made. Even so, I just want to list what, on the face of it, seemed like some compelling arguments in favor of doing so. And this not just comes from the government or its sympathizers, but from some other sort of independent minded people. uh, the fact that doing so would increase labor force participation of women, that it would reduce maternal and infant mortality, because young girls who are just turning 18 almost immediately get pregnant after they get married, and therefore if the age limit were to be pushed legally to 21, that could perhaps be brought down further. Some even arguing that this is a legal fallback against parents who push girls to get married as soon as they turn 18, and that perhaps this will allow them to explore higher education and work. So, as I said, on the face of it, they seem like compelling arguments.
See, I think I mean, the national data is very you know is very illuminating on these points. So if you look at the malnourishment, the what NFHS talks about in terms of anemia and stunting, so it doesn't matter whether the girl is 18 or she's 21. If she's malnourished, she remain malnourished. So one has to address it through nutritional inputs. It cannot be that malnourished girls will now have children only when they're 25, because we fear that their bodies are not capable. Well, if they that we need to tackle malnourishment head on. So that's one. And there are I think various people who worked in this area and have written on it. The second thing about women's participation in labor force. Now we are seeing actually unemployment. I think there's been a lot of conversation on that also, writing in journals and media about the high levels of unemployment and women's labor force participation being one of the lowest in India as compared to the world. So I think that again needs to be tackled at a different level. And it's, we are talking about women going in for higher education, but when we see the correlation between poverty, uh, and infrastructurally deprived rural areas and early marriage, you will understand that where are these girls getting their higher education? They're not even finishing their secondary schooling. So we are actually talking about two different sections of society. So if we are looking at the whole issue of age of marriage, yes, those living in cities will say, great, it works for us, because maybe they can negotiate with their parents because they're already going to school and they have a choice of, one going to a college or something. But those who are laboring already, they're pulled out of schools in order to work at home. They don't have that leverage. They don't it's not an option for them but to work either in their natal homes or in their marital homes. So I think we're talking about two different societies, both of whom are integral to India. So what we do need, and I will say that since you raised this question of girls don't want to be forcibly married off, that's very true. um, if we look at the studies done by Partners for Law in Development, a lot of the self-arranged marriages that uh, that girls elope and then marry. We've done qualitative studies as well as the case law analysis. A lot of the times, girls run away from homes because they are fleeing a forced arranged marriage. That is one of the biggest triggers. And so we don't have a law. Yes, we do require consent of the girl, but we don't have a law or any offense around forced marriage. And section 12 of the PCMA, which declares some marriages to be void, where enticement, kidnapping, and so on, trafficking are involved, does not talk about parentally forced marriages. In fact, I've come across cases where the girl has told the court she was forcibly married, and the court says, but we can only look at the age of marriage. If you're a minor, you can void the marriage. But if you are not a minor, then you can only divorce. So you see that this whole business of forced marriages, because that's a huge problem in India. And if you look at international law at the UN, there are resolutions against forced marriage. There are countries like UK, Germany, Canada, which have whole policy frameworks and laws on forced marriage. And South Asia, including India, is a country of interest in those contexts, because we also have transnational forced marriages, right? We have diaspora living in other parts. So forced marriage is a real issue, and I don't wish to undermine it. And girls are terrified of that prospect, which is why they would want, but to make the age of marriage 30 or 40 is not the answer. Forced marriage has to be tackled as forced marriage, and minimum age of marriage should be correlating with the age of majority. There is no reason why a girl at 14 can work in a non-hazardous industry, but she cannot marry until 21. In fact, the PCMA also is very interesting because there is an inconsistency. A boy is a child for the purposes of marriage until 21,
21.
but
Correct.
may be punished if
Under
he
POCSO.
marries a girl of 16 and he's 18, because for that majority, for punishment, majority is enough, but for marriage it is the definition of child. So there are these inconsistencies that don't hold. And it really, I mean, I think the underlying issues that girls are expressing are real, but the solution is not like changing the minimum age of marriage to uh, to 21 will actually undermine the civil liberties of young women. It takes away their right to decide on personal matters. They become child. We can't undermine the rights of women who are able to vote, who are able to work, but they cannot able to contract, but they may not marry. So I don't think that that is really. I think the underlying problems are real and need to be addressed, but this is not the pathway. This is just in a sense very sort of symbolic, and may make people feel that, oh, this is going to make some difference. But if you look at all the wealth of studies and data available with the government, that's really not that's really not going to get us anywhere.
I'm sure for a lot of our viewers, what your study found about how the law, in fact, was weaponized by parents to undermine the agency being sort of exercised by their young daughters would be illuminating and come as a surprise, as it did to me when I first sort of read the report. Thank you, Ms. Mehra, for this conversation here with Scroll, and for sort of providing your insight on what are clearly many interconnected issues, and a very sort of nuanced conversation requires to be undertaken and carried forward. So we hope this will sort of add to the discourse on it. Thank you for the moment.
Thank you so much.